Today's episode is brought to you by Mazars.
SoundCartel.
From SoundCartel, I'm Nicole Goodman, and this is Business Essentials Daily. Very soon, more employees will have the opportunity to request flexible working arrangements. That's a result of changes to the Fair Work legislation, which has widened the definition of those seeking more flexibility. The legislation takes effect on the 6th of June, and it also means that employers will have new obligations before they can refuse a request from an employee. So, under the Fair Work Act, who can request a change to their working arrangements? HR and industrial relations expert Cheryl-Anne Laird of Mazars explains to Chris Ashmore.
Firstly, a parent or have responsibility for a child or a child who is of school age or younger. They are a carer. They have a disability. They are 55 years or older. They are experiencing violence from a member of their family, or they provide care or support to a member of their immediate family or household who requires care or support because they are experiencing violence from their family. Also, if an employee is the parent of a child or has responsibility for the care of a child and is returning to work after taking parental or adoption leave, the employee may request to return to work on a part-time basis to help them care for the child. The only other limitation is that employees, even if they fit into the above category, can only make requests under the auspices of the Act if they have at least 12 months continuous service with their employer immediately before they make the flexibility request.
Any examples of the types of flexibility that employees are able to request?
They generally fall into categories of changes in hours of work, for example, a reduction in the hours work or change to the start and finishing times. Changes in the patterns of work, for example, working split shifts or job sharing arrangements, or changes in the location of work, for example, working from home or from another location.
And what about casual employees? Do these flexibility provisions also apply to them?
Yes, casual employees who fit into the category of they have been employed by their employer on a regular and systematic basis for a sequence of periods of employment of at least 12 months immediately before they make the request, and there is a reasonable expectation of continuing employment by the employer on a regular and systematic basis.
How does an employee make a flexibility request?
What you need to do if you want to make a flexibility request under the Act is request in writing the flexibilities that are being requested, including details of the changes sought and the reasons for the change.
And what are employers obliged to do to respond?
Employers then have 21 days in which to provide a written response to the request. Employers may only refuse a flexibility request under the Act on reasonable business grounds, and if they refuse a request, they must set out the reasons for the refusal in their written response.
And what's meant by reasonable business grounds?
Reasonable business grounds will vary from employer to employer, subject to their individual circumstances. However, I can provide a list of things which have been identified as the types of reasonable grounds which may allow an employer to reject a request for flexibility under the Act. These are that the new working arrangements requested by the employee would be too costly for the employer, that there is no capacity to change the working arrangements of other employees to accommodate the new working arrangements requested by the employee. It would be impracticable to change the working arrangements of other employees or recruit new employees to accommodate the new working arrangements requested by the employee. The new working arrangements requested by the employee would likely result in significant loss of efficiency or productivity, or that the new working arrangements requested by the employee would be likely to have a significant negative impact on customer service. However, the list I've just provided are examples only, and there will be many more circumstances where reasonable business grounds exist for a particular employer. Importantly, the Act does not require an employer to restrict its consideration of a request to the specific request of the employee. Rather, employers and employees are encouraged to discuss the request, and if the request set out in the initial application cannot be granted, to explore collaboratively if there are other working arrangements which can be approved, which would balance the needs of both the employer and the employee.
If the employer refuses an employee's request, what rights does that employee have?
There are currently very limited options for an employee who is dissatisfied with a decision by their employer on a flexible work request. In some instances, an employee may be able to pursue the matter to the Fair Work Commission to deal with the issue as a dispute under an award or enterprise bargaining agreement. However, the recent amendments to the Fair Work Act, incorporating the Secure Jobs, Better Pay Act amendments, will provide broader and easier access to the Fair Work Commission from 6 June this year, as well as some other process changes. So from 6 June 2023, employees will be able to make a flexible work request, and if they are dissatisfied with the response from their employer, will be able to make an application to the Fair Work Commission. The amendments introduce new provisions empowering the Fair Work Commission to resolve disputes regarding such requests. The new dispute resolution mechanism applies in circumstances where an employer has either refused a flexible work request or not provided a written response to a flexible work request within 21 days, and the parties are unable to resolve the dispute through discussion at the workplace level. The Act stipulates that where a flexible work arrangement dispute arises, conciliation should be the first avenue of dispute resolution unless there are exceptional circumstances. However, where conciliation is unsuccessful or if urgency is required, the Fair Work Commission will have the power to deal with the dispute as it considers appropriate or through mandatory arbitration in accordance with the new Section 65C, which is referred to as the arbitration clause of the Act. Under that clause, the Fair Work Commission can make binding decisions, including an order that an employer be taken to have refused a flexible work request where the employer has not responded within the prescribed 21 days, or where the employer has refused the request, an order that it would be appropriate for the grounds on which the employer refused the request to be taken or not be taken as reasonable business grounds, or an order that the employer provide the employee with a written response to their flexible work request. Orders under the amended provisions of the Fair Work Act, of course, can't be inconsistent with the Act itself or a term of an award or industrial instrument which applies to the employee. These provisions come in on the 6th of June this year. Therefore, we will get more clarity as to the scope of the Fair Work Commission powers once we start to see some case law being decided on applications for dispute resolution.
Other than the extended jurisdiction of the Fair Work Commission, are there other changes from the 6th of June?
Yes, there are also process changes for how requests must be managed at the workplace. The new section of the Act, 65A, will require an employer who receives a request for flexible work arrangements to meet with an employee to discuss their first flexible work request, and where the employer intends to refuse the flexible work request, agree upon alternative changes to the employee's working arrangements and note the agreed changes in the employer's written response, or if the employer still intends to refuse the request, outline the employer's reasonable business grounds for refusal and address the following: changes to the employee's working arrangement that would accommodate to any extent the employee's circumstances and that the employer would be willing to make, or that there are no changes the employer could make to accommodate the employee's circumstances.
Well, 6th of June is not that far away, Cheryl-Anne. What should employers do between now and then to prepare?
Well, the practical effect of the proposed changes from 6th of June will expand an employer's current obligations under the Act in relation to flexible work requests to also include an obligation to meet with the employee and discuss their request for flexible work arrangements, an obligation to inform the employee of any changes to working arrangements the employer is willing to consider to accommodate an employee's circumstances, and potentially engaging with a Fair Work Commission process to resolve disputes around the management and refusal of flexible work requests. We would encourage employers to commence the process of reviewing their current practices for considering and responding to requests for flexible work arrangements, including updating or implementing policies or procedures on flexible work arrangements to ensure they are consistent with the extended obligations which will commence on 6 June. In particular, employers should ensure that they are clear on how they will engage with employees who make a flexible work request, and also be aware in advance of what genuine limitations exist within their business, which would limit their ability to offer flexible work arrangements, and how, if challenged, the employer could demonstrate these limitations are in fact genuine and constitute reasonable business grounds.
That was Head of the HR and IR Division at Mazars, Cheryl-Anne Laird. This episode of Business Essentials Daily is produced by the team at SoundCartel. Thanks for listening. I'm Nicole Goodman. We'll bring you more Be Daily tomorrow. Follow at BE Daily Podcast across social media and head to bedaily.com.au for more from the Business Essentials Daily podcast. SoundCartel. This episode was brought to you by Mazars. To find out more, visit mazars.com.au. That's mazars.com.au.